Hello, kia ora, Lucia here, property investment mentor and founder of the Finax Mortgages and Insurance. This is the recording of 1 hour live webinars. If you would like to join us in our next webinars and be part of the Q&A, please head to our website, luciaxiao.co.nz. I trust you will definitely learn a lot from this video. Thank you. Beautiful. Yeah. So good evening, everybody. And I probably just quickly introduce myself, just in case that, for some of you, you don't really know who I am. So my name is Lucia, and I am a property investment mentor, mortgage and insurance advisor, and also founder of the Finax Mortgages and Insurance. So basically, our role is actually just helping people to buy their home, or if they are buying their investment property, we're teaching them how to actually add value. Also, I'm an author of the book called Financial Freedom 5 Steps, 5 Years, and just a personal story of myself. When we were living in the 1-bedroom flat at Papa Toy, and then managing $170 a week after we paid the rent. To later on, I was able to build a $17 million property portfolio in 5 years. So now the portfolio probably looking at like heading to $30 million now. Yeah, so it's quite nice to see that, and I do believe that if I can do it, and you guys can do it too. Okay, so obviously, I mean, at the moment in market, there are a lot of changes. I think our government actually love to give us a surprise. Yeah, so joining us tonight is Annette from Pinton Lawyer. So Annette has a really strong background in immigration laws, and I think that's what she enjoys doing as well. And also she's a family law lawyer as well. So do feel free to actually leave your questions in the chat box. Yeah. Okay, so I'm just going to hand over to Annette. Yeah.
Thank you. Thanks, Lucia. And I think I'd definitely like a copy of your book, please. So my name's Annette Woodroffe, and I'm a senior lawyer for PCW Law. We're based in Auckland. My specialty of law is immigration law. And this is a really quite exciting time for immigration law because there are a lot of developments. And I think that we can expect to see a lot of changes in immigration policies in the future. So tonight we are going to talk about a very new policy that's just come out, which is the new 2021 resident visa. Now, this was just very recently announced by the Minister of Immigration on the 30th of September. And so tonight we're going to have a discussion about this and look at various aspects around this. Okay, so this is what we're going to discuss tonight. I think it's really important to have an understanding of why this new policy has been introduced. I always think that if you understand why something is there, it will help guide you through and give you a better understanding through the application process. Secondly, we're going to discuss the actual criteria. So what criteria do you need to meet in order to be granted residence under this policy? Thirdly, when can you apply? And then fourthly, should you apply under this policy? Here we'll be discussing the benefits of applying under this policy, which I think there are many. Then we will discuss meeting the requirements for, and I've put in quotations, work in a role on a scarce list. Now, this is one of the criteria that you may need to meet when applying under this policy. And I've specifically chosen to discuss this criteria because I believe this will be the criteria which will probably have the most analysis or the most scrutiny by Immigration New Zealand. Lastly, we're going to talk about some practical tips for immigration applications. Now, this is really, really important to me because at the end of the day, I want my clients to get their visas, and obviously they want to get their visas. So if we can look at the best way of setting up an immigration application, then that is how you will have the best chance for success. Okay, so Why has Immigration New Zealand introduced a new resident visa policy? Well, I think it's fair to say, and I think everybody would agree, that COVID-19 has changed the world that we live in, and particularly within the employment landscape. And the world that we had when the current policy was introduced is very different now. Another problem is that Immigration New Zealand has a large backlog of applications to process, and anybody who has lodged an immigration application at least over the last 12 months will understand about this backlog and how slow the processing is happening. The skilled migrant category, which was quite a substantial pathway to residence in New Zealand, has been on hold for over a year. This means that a lot of people have been living and working in New Zealand with uncertainty over their path to residence in New Zealand. This is not a satisfactory situation. People need to be able to plan for their futures. And on that basis as well, there is also a risk that New Zealand will lose a lot of potential skilled workers that are needed in New Zealand. It is estimated that this will affect around 100,000 people. So immigration are estimating about 100,000 applications. So you can see that this is going to be quite a large-scale operation. Okay, so let's talk about the policy and the criteria. What do you need to meet in order to be granted residence under this policy? So, step one, you need to show, or you need to prove that you were in New Zealand on the 29th of September 2021. And secondly, that you held an eligible visa or that you had applied for an eligible visa on or before the 29th of September 2021. And if you had applied for one before that, then you need to show, well, that visa needs to have been granted at a later date. So let's just take an example. You applied for an Essential Skills Work Visa on the 1st of September 2021, and that may be granted, say, in November. Then you will still be eligible under this criteria. Now, what is an eligible visa? So essentially, these are work visa holders. So we have post-study work visas, the talent accredited employer work visa, essential skills work visas, religious worker work visas, and you can see the list just down the right there on the presentation. So these visas are basically premised on the fact that most of the people who are holding these visas will have jobs and will be working in New Zealand at the moment. Now, it's really important to note that partnership work visas are not included. The reason, my thoughts on why they're not included is that this policy is to give people who are working in New Zealand a pathway to residence. People who hold partnership work visas have a possible pathway to residence through the partnership policies. Now, that said, I have just thought it's important to note that some people may be on a partnership work visa, but their partner may be on an essential skills work visa. So if their partner qualifies under the essential skills work visa, then you can be included in the application as well. Now, just to note as well, some people who hold critical purpose visas will be eligible to apply as well. And those are people who must arrive in New Zealand and apply before the 31st of July 2022. And they are critical health workers who are in longer term roles, so it's 6 months or longer, and other critical workers who are in long-term roles, so that is for more than 6 months. So just to go over that, that is step one. You need to have been in New Zealand on the 29th of September 2021, and you need to have been on an eligible visa. And the only exception to that is the people on the critical purpose visas, which I've just mentioned. Okay, Step 2 of the criteria. So once you've satisfied step 1, you can have a look and see whether you satisfy step 2. Now there are 3 options here, or 3 different criterias. You only need to satisfy one of these criterias, not all of them. So the first criteria is, have you lived in New Zealand for the past 3 years or more? Now, you must have arrived in New Zealand on or before the 29th of September 2018, and you must have spent a minimum of 821 days in New Zealand between the 29th of September 2018 and the 29th of September 2021. Now, please note, those days do not have to be consecutive. They can have breaks in between them, but in total, you need to have had 821 days. The second criteria, which you may be eligible under, is were you earning at or above the median wage on the 29th of September 2021? So this means you must have been earning $27 per hour or above on the 29th of September 2021. So here the date is key. You can't all of a sudden try and get a pay rise to meet this, because they will be checking as of that date. That is the salary that you were earning. Now, the third criteria is, were you working in a job that is on the scarce list on the 29th of September 2021? Now, the scarce list are jobs that are listed on the long-term skill shortage list. They're jobs that require occupational registration in the health or education sector, or personal carer jobs and other critical health workers, or specified primary sector jobs. Now, there are many occupations that are on these lists, so that is why I have not listed them. If you do not meet one of the first 2 criterias, then I would suggest that you get advice to see whether your occupation is on the scarce list. Now, we're going to discuss that a little bit more a bit later. So we'll move on and we will come back to that point. But just a recap, that for step 2, you only need to meet one of these criteria. Right, just some other points as well. It's always useful to know as much as you can about a policy. So I did mention this before, but partners and dependent children can be included in the application, and this is regardless of whether they are in New Zealand or not. So in terms of the eligibility, it is the principal applicant who needs to have been in New Zealand on the 29th of September 2021, but you can still include your partner and children even if they were not in New Zealand. All applicants will need to meet health and character requirements. You can, now, as you will remember, one of the criteria was that you have to have lived in New Zealand for 3 years. If you're not sure, sometimes it's hard to keep track of how many days you've had here. You can request a copy of your travel movements from Immigration New Zealand, and that will provide information so that you can be sure how many days you have had in New Zealand. They are estimating that processing time for this policy will be about 12 months, although they have said it may be faster in some cases. Now, the next point is a very important point, and this is a point that I'm continually discussing with my clients. When you make an application under the residence policy, and it doesn't matter which policy it is, you must meet the criteria of that policy. There is no discretion for residence policy. This is different from temporary visas. So visitors visas, student visas, work visas, an immigration officer has some discretion to decide whether or not they want to grant you with the visa. For residents, you must meet the policy, and if you meet the policy, then immigration must grant you a visa. If you do not meet the policy, then they must decline you. Now, I raise this point because, we always get questions and unfortunately people who just fall out of the policy. So, for example, somebody may say, well, I haven't had 821 days in New Zealand, I've had 820. Will I still meet the policy? The answer is no. If the policy says 821 days, then it is 821 days. There is no discretion around that. There is no grey area. It's very black and white. The same thing for earning. If somebody said, well, I was earning $26.50 and I got a pay rise on the 1st of October, again, that will not meet the policy. Now, I just want to note there as well that the whole purpose, as we discussed at the beginning, of this policy is to allow people who have been working in New Zealand a pathway to residence. So if you're a visa holder, so even if you hold the work visa or essential skills work visa, but you are not inside New Zealand, you are in another country, then you are not eligible to apply. Now, there may be an exception, and this has not been fully announced yet. There may be an exception for people who were in Australia and they could not get back to New Zealand at the time. So if you do fall into that situation, then just keep an eye out. Don't think you're out of the picture just yet. There may be an exception made for that. Obviously, we had our borders closed to Australia, and a lot of people who are usually living in New Zealand have been caught out and possibly have been stuck in Australia. So I think that there will be something to address that. Okay, when can you apply? So there are 2 dates, and they are opening the application process up in 2 phases. So phase 1 is you can apply from the 1st of December 2021 if before the 29th of September you had already applied for residence under the skilled migrant or work to residence instructions. So that means you already had a residence application submitted, or you had submitted an expression of interest under the skilled migrant instructions, and that expression of interest included a dependent child who was aged 17 or over on the 29th of September 2021. So basically, from the 1st of December, if you had already applied for residence under skilled migrant or work to residence, and there is that one exception if you had submitted an expression of interest and it included a dependent child who's 17 years or over. Everybody else who is eligible will be able to apply in phase 2, and that date is from the 1st of March 2022. Now, it's really, really important to note that at the moment, Immigration are saying that all applications must be submitted by the 31st of July 2022. So that is the final date that you must apply by. My recommendation is always never leave things to the last minute. Things can tend to go wrong, so try and get your applications ready and submitted as early as possible. And, we can't rely on the fact that Immigration might give us an extension. I think everybody should consider the 31st of July 2022 as a hard deadline. Okay, the next thing we're going to discuss. Should you apply under this category? Now, this might seem like a bit of a strange question, but actually some people have already submitted their residence application under the skilled migrant instructions or work to residence instructions. So for these people who already have a residence application processing, is it worth it? Is it worth submitting a second residence application? Well, in my opinion, and every case is different, but in general, it is worth it. And the reason is that eligibility criteria is very different under this new policy. So under under the new 2021 residence visa instructions, as you will see, we've just set out the criteria, and it's not as onerous, or there's not as many criteria that you need to meet as there are under the skilled migrant or work to residence instructions. Now, another big thing for me, and that we've seen a lot, is under the skilled migrant and work to residence instructions, often the employer is required to show that they are sustainable and that they've complied lawfully with all employment laws and immigration laws. Unfortunately, there's been many circumstances where the applicant themselves have everything correct, they meet all the criteria, and there's absolutely no problem with the applicant, but their applications have been declined because of issues with the employer. And that's a really unfortunate situation to be in. And as an applicant, it's also a situation which is a lot of the time out of your control. And it depends solely on your employer. So this requirement is gone, basically. You do not need to meet the employer sustainability or show lawful compliance by your employer. So that's a major obstacle that is taken away. And in my opinion, and I'm sure everyone will agree, that if you have less criteria to meet, then your chances of success are better. And that is why I think it is worthwhile, even if you do have a residence application pending, it is worthwhile giving this policy some serious consideration because it is likely that your chances of success will be a little bit better, or will be better under this policy. But always, if you're not sure, and as I say, every case is different, you should seek legal advice about this. Now, you'll remember earlier we discussed that one of the possible requirements that you might need to meet is that your work is on a scarce list. And I mentioned at the time that we would come back to this. Now, the reason that I want to specifically discuss this requirement or this criteria is that I anticipate that this will probably be the most problematic. And by problematic, I mean that if you do need to meet this criteria, that this is one that will probably have the most scrutiny by Immigration New Zealand. Now, this is because we've seen the way that occupations are assessed by Immigration New Zealand under the skilled migrant instructions and under work to residence. So I think at the moment, because this is a new policy, we don't know exactly how Immigration New Zealand are going to process them, but I think we can have a pretty good idea from our experience with the way that they've processed those other residence applications. So if you are applying under this criteria that your job is a work on the scarce list, then step number one is that you need to ensure that your position matches one of the listed occupations. So let's just take an example. If you are an engineer or electrical engineer, then and that is what your job title is, and the work that you do, then you need to make sure that your position as electrical engineer is one of those ones on the listed occupation. But that said, it is not so much about job title. It is more about what tasks you do in your role. And this is another really, really important point, because so many times we get asked, what job title do I need to put on my employment agreement? Now, it is important that you get the job title correct, but just because you have electrical engineer written on your employment agreement does not mean that immigration will accept that you are doing that job. What they will look at is what your tasks are in that job. What are you doing in your position? So the starting point, of course, is making sure that your duties that are listed in your employment agreement, those of an electrical engineer, but also that actually what you do day to day. Do you do that position? Is that your main position? Now, when we talk about tasks, these are likely, because this is what immigration use at the moment, to be taken from what's called the ANSCO Code of Occupations. So ANSCO provides a list of tasks for every occupation. And immigration, when they assess whether your job matches an occupation, that is, for example, on the long-term skill shortage list, they will want to make sure that the work that you are doing or your tasks are substantially the same as what the tasks are set out in ANSCO. And this is why I think this is going to have the most scrutiny, because immigration always, they check very thoroughly and they want to make sure that you are a substantial match. So, for example, if you are an electrical engineer, but actually you spend most of your time answering the phones in the office, then, and about 10% of your time doing some electrical work, so I'm not an expert in electrical engineering, then obviously immigration are not going to be satisfied that your job is a substantial match to an electrical engineer. And it doesn't matter what you have written on your employment agreement for your job title. So this, I just want to emphasise this again. Job title, yes, it's important to have that correct, but make sure your tasks, what you are doing in your job, are a substantial match to whatever the occupation is in ANSCO. Okay, this is a bit that I really want to talk about and I find the most exciting, because this is where I want to give some advice on how to give yourself the best chance on getting getting any immigration application approved. And so here are some practical tips for immigration applications, and you will see there that I've put evidence, 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 because the evidence that you submit with your application is key. Now, first of all, get it right from the start. Put some effort when you are getting your application together. Put some effort to make sure that you have as much evidence that you can to prove that you meet the criteria in the policy. And then make sure that you have enough evidence to support each criteria in your application. So let's just take the current policy that we're talking about as an example. So to meet step number 1, obviously, were you in New Zealand on the 29th and did you have an eligible work visa? Of course, a copy of your work visa. Now, I know Immigration New Zealand will have this on record, but I always say include it in. So then you know that you have ticked off proving that criteria. Okay, then, for example, if you are going to apply under the fact that you were meeting the median wage, you need to prove that you were earning $27 per hour on the 29th of September. Pay slips, bank statements showing that that was what you were being paid, and a copy of your employment agreement or any variations to your employment agreement where you may have received a pay rise. All of those will be needed to support that criteria. It is up to you to provide the correct evidence and to provide enough evidence to support your application. So evidence, that making sure that you have enough evidence in your application is your responsibility. Immigration New Zealand may not ask. Sometimes they come back and ask for specific things, but at the end of the day, immigration officers, if they're not satisfied, they will say you have not provided me enough evidence to satisfy me that you meet that criteria. So how do you avoid that? You avoid it by making sure you do give enough evidence and that it is the correct evidence to support what you are trying to prove to immigration. Now, the next point, this is very important as well. Look at your application objectively. And this is where it's always a really good idea to have a lawyer or someone representing you, because a lawyer will look at your application objectively. So many times something that may make sense to you or something that may seem very obvious to you may not make sense or may not be obvious to an immigration officer. I always remind my clients when they come to me that when they're talking about their jobs, they know what they do and they know what they're talking about, but other people don't. And so sometimes you have to go step by step and explain it to an immigration officer exactly what you do, and then have the appropriate evidence to support what you are saying. So it's really important when you are making immigration applications, do not assume that the immigration officer will understand or that what you are saying makes sense. Be very careful. Even if you think you're oversimplifying things, it is better to oversimplify than to let an immigration officer miss your point, which could then cause your application to be declined. The next point, is your evidence credible? Unfortunately, we see a lot of documents come through our office, and even to my eye, I can tell clients straight away that Immigration New Zealand won't believe the document, and so there's no point submitting it. There's no point submitting a document that Immigration New Zealand are not going to believe is real and genuine. So, for example, are letters on letterhead? Is there contact details? If you are submitting a letter of support from family or friends, make sure that they sign the letter. Make sure that there's contact information, so if immigration want to check anything, they know that they can. It's really important to make sure that what you are submitting is genuine and that it looks genuine. Another thing that we've had come through, another client who was with an immigration advisor, some of their photos were photoshopped. Obviously a big no-no. And as soon as, if you put in something that is not credible to Immigration New Zealand, you put yourself on the back foot straight away. And that's not what you want. You want Immigration New Zealand to believe you or to want to believe you. And this is something that's very important. And over the years that I've been working in immigration law, I've worked really hard to build up credibility with Immigration New Zealand, so that they know that if something comes from me as a lawyer or from our office, then it doesn't mean that immigration will always accept it, but at least immigration will always consider it, and that it will be credible information as best as we can. So that is very important. Next point, is your evidence consistent? Look, not everybody's got a perfect memory. We all forget facts and dates and times and details. But unfortunately, when it comes to Immigration New Zealand, just saying I forgot or I got confused is not a great answer. So when you are preparing applications or when you are preparing evidence to give to Immigration New Zealand, make sure you go through everything properly, application forms, and this, you know, your lawyer or advisor should be doing the same, to make sure that things match up. You know, if you have a letter from your employer saying that you started on the 19th of March 2020, then you don't want to put in anything else that says actually you started in April. These are little details that immigration pick up on, and then they get concerned that you may not be providing them with correct information, or even sometimes they may raise concerns about misleading information. So this is something where you can it's in your control, and you can do yourself a favour by just making sure that everything that you are putting into Immigration New Zealand is consistent. Now, just another point about evidence and why it is so important to get your evidence correct at the immigration application stage is because if you find yourself in a situation where your residence application gets declined by Immigration New Zealand, then you do have an appeal right, and you can appeal that decision to the Immigration and Protection Tribunal. However, if you lodge an appeal to the tribunal on the basis that your residence application or that the immigration officer's decision to decline your residence application was wrong in terms of policy, then you are not able to submit any new evidence to the tribunal. You are stuck with the evidence that you submitted to Immigration New Zealand. So again, and unfortunately, I get a lot of people coming to me when they've received a declined decision on a residence application and looking to appeal to the tribunal, and that is definitely one of my areas that I enjoy. Doing appeals to the tribunal, but the difficulty is sometimes when people have lodged applications themselves or through other representatives, we find that we are stuck with the evidence that has been submitted, and so often there is actually more evidence that could have been submitted and better evidence that could have been submitted. And I always find it a real shame that people did not give themselves the best chance or put their best foot forward when they were in the application stage with Immigration New Zealand. So as you can probably tell, it's a very, very important thing to me, or an important issue to me, but just getting that evidence correct, giving the best evidence that you can. There's not always a set checklist for what evidence to provide, and this is why I say get legal advice. Sometimes and often I'll sit down with clients and they can't meet a set checklist, they just don't have that evidence. And so then we need to start thinking outside the box. What evidence do you have? What evidence is available that we can put in? So I definitely, that is, if you get legal advice about that, then any legal advice you receive there should be a large focus on your evidence and making sure that the evidence is correct. Okay, so on that point, just so I can keep labouring on about the importance of evidence, but we're just going to look at a case study. And this case study is based on one of my clients, so client A. And this is just an example of the issue with evidence. So client A had a previous advisor before coming to us, and they had applied for residence under the skilled migrant instructions, and the role or the occupation was marketing specialist. Now, client A had received a Ppi Letter. For anybody who doesn't know what that is, it is a letter which immigration will send out listing any concerns they have with your application, and PPI stands for potentially prejudicial information. And this is because immigration have a duty under our laws to notify you if they have some information that could cause your application to be declined, and they have a duty to allow you to respond to it. So immigration had sent to client A a Ppi letter, and they had said that they were not satisfied that their role was a substantial match to the ANZCO role or to the ANZCO occupation and lists of tasks for a marketing specialist. Now you can see here from the list there were a lot of concerns, and these sort of concerns do come up quite a lot. So their concerns were that they said client A had failed to explain how they had developed policies and campaigns to support sales and objectives. that they had failed to elaborate what factors were taken into consideration when conducting research and how the research supported the business. They had concerns about WeChat advertising, which Client A had done, but they were concerned about how that advertising was impacting the business. They had concerns about exactly what information were in the monthly and annual reports which Client A said they were doing. They had concerns about how WeChat was used to plan and develop advertising policies. Concerns about how Client A was planning and developing promotions. Concerns about how Client A was identifying market opportunities if the market was limited to Chinese consumers, and that was what Immigration New Zealand had decided in this case, that it was only Chinese consumers, and said that Client A did not explain how they were assessing customer behaviour and consumer purchasing patterns. Now, another reason that I've set out all these concerns is because this is an example of Immigration New Zealand having a look at an occupation and the level of scrutiny and analysis which they take to make sure that what you are doing in your role or what you are doing in your job is a substantial match to ANZSCO. So in this case, there were quite a few concerns, as you can see. So Client A, after receiving their Ppi Letter, came to see us at PCW Law, and we met with Client A. And when we met with Client A felt that they had already provided full explanations to Immigration New Zealand about this, and they felt that they did not have any more evidence which they could provide to Immigration New Zealand. So obviously, as a legal advisor, as a lawyer, when a client comes and says that, we have to take a tough line and we have to be very realistic and very practical. If a client is saying that they feel that they have provided all these explanations and they've provided as much evidence as they can, and immigration is still coming back with a big long list of concerns like they had in this case, then obviously I think it's very clear that the evidence and explanations which had been provided were not good enough. And so it is our job, when you respond to a PPI letter, to do better, to make sure better evidence and better explanations go in. So in this case, and in every case, we considered exactly what kind of evidence Immigration New Zealand would want to see to prove each concern. You need to break it down. Every concern needed to be broken down. And I have noted here, when you are at this stage or in this position, it is best to go and get legal advice, and especially from someone who has experience, because this can get very technical. And as I say, you know, this is residence applications. They're very, very important. And we understand how important they are to our clients. And obviously everybody wants to see a successful application. So we discussed with the client what more evidence that they could have. So even if a client comes to me and says, I've given everything I can, I know that there is always more, because there has always been more. So this is about thinking outside the box, having a very, very real discussion with the client, and about, even if we're breaking down into specific details. So in this case, there were more. There were more reports that could be given. There were emails, evidence. You know, there were questionnaires that had been sent out, so we could get screenshots of questionnaires that had been completed. Those are some examples of more evidence that we could get. So once we have the new evidence that we are going to submit and evidence to prove each concern or to answer each concern, the next thing we check, which is what I've discussed about, is does this evidence look credible, and how can we prove the credibility of this evidence? So I want to take some examples. Often people might say, well, I wrote this policy, this was written by me, and I want to submit this policy as evidence that I write policies as part of my job. Or it may be, you know, I make this report, I wrote this report and, you know, I'm going to submit this report. But immigration will look at that and they will say, well, this is great, the information is good, but actually, how do I know that you did this? How do I know it wasn't a colleague? And how do I know that you haven't just put this together now because you have received a PPI letter? And unfortunately, this is, we have to be realistic that these are the thoughts that immigration officers will have and will consider. So in this case, where there was a policy or where there is a report, how do we prove that our client actually did it? Well, often reports are emailed to the manager or to other staff. So even just printing out a copy of the email, which shows the attachment and shows that they have sent it out saying, here is the report that I have done, and it shows the date. That's a really good way. Otherwise, you just have to keep discussing. Another example that we may use is that, and in this case as well, we did getting letters from the employer or from managers to confirm that yes, this report was prepared by client A. This is the date that it was prepared. This is the reason it was prepared, and perhaps maybe and it was presented on this date. So it's not always just about getting the documents and the evidence. Then you need to take it a step further and you need to think, will immigration believe that this evidence is from me? Is this evidence credible? Now, the next step in the puzzle or in the journey is providing clear explanations to Immigration New Zealand about what evidence is being submitted to address each concern. So obviously in this case study with client A, there was a long list of concerns. And there was a lot of extra evidence that we submitted. And in what we call our submissions, we make submissions to Immigration New Zealand on behalf of our clients. We addressed each concern. We set out which evidence was being submitted for that concern and how that evidence should satisfy the concern. I think the important rule of thumb here is to make it easy for the immigration officer to understand. We want to make their job easy. We want to make it easy for immigration to approve an application. And in this case, we're very happy to say that client A's residence application was approved, and I think that was approved pretty quickly. I think it was 1 to 2 weeks after we sent the response. So that was a really great result, and that is an absolute example where the evidence that had been submitted was not good enough to satisfy Immigration New Zealand, and we managed to turn that application around by submitting better evidence and by working with the client to make sure as much evidence could be submitted as possible. Okay, well, this is a lot of talking from me. And so, as I say, we work with, I'm a lawyer at PCW Law, and here's some information that we're just putting up about PCW Law. So we are a one-stop law firm, and we range in criminal cases, property law, commercial law, and litigation, and of course, immigration law. We have experienced lawyers, so most of our lawyers are over 15 years experience. And we pride ourselves on working with our clients to find prompt and cost-effective solutions. Okay, and then here, there are just some contact details.
Right, okay, yeah. Thank you, Annette. Yeah, I mean, very professional and also very thorough in terms of the policies and also like how to apply that. And I think, again, I think I'd like to remind you that although you might be able to do it by yourself, but it's actually, because that's actually probably for some of you, it's actually once in your lifetime. You do not want to, get it wrong. You want to make sure that you can just get it right. Yeah,
that's absolutely right. It's all about putting your best foot forward. This is, residence is very important. It is your future, and it is the future of your family. And often by the time you apply for residence, you may have children who are settled at school. You've spent or invested a lot of money in New Zealand, so you want to make sure that your residence application goes as best as possible.
Yeah. All right. Okay. Thank you. And then, so we got a few questions here.
Okay.
So yep. This one's from Darren's asking, do they have a working hours requirement?
No.
Oh, so as long as it's $27 per hour, it can be a part-time, is it? Yeah.
Yeah.
Okay, awesome.
Now, but that said, usually if you are on work, say, for example, you are on an essential skills work visa, the requirement for those visas will be that you are in full-time work. So not for this policy, there is no hourly, a full-time work requirement, but that may be a requirement of the temporary visa that you are on.
Right, okay. We got another question from Nerden. So basically, they're asking, we are on South Island contribution work visa and applied for residency last year, July. Our conditions was to stay in the same region after getting residency. So if we go under this category, does it mean that we don't need to stay in the same region anymore?
That's a really, really good question. So often with other residence policies, there may be what's called Section 49 conditions or conditions put on you. Now, as of this moment, Immigration New Zealand have not said that there will be any conditions if you're granted a residence visa under this policy. So that would be a difference between the two policies.
Okay. And also another question from Nerden. So I heard they will process this category before the 1st December this year, but our application was on paper and Auckland being on level 3, and they can't assess the application. How would that happen?
Yeah, so at the moment, if you have submitted, you're obviously talking about an application that's already been submitted. Unfortunately, if they are a paper application and they're being processed in Auckland and Waikato at the moment, then they are on hold. They're not being processed. But that does raise a very good point that any applications under the new resident visa policy, they can be, I understand that they will be able to be submitted online. And I think that given the current climate and taking heed of what has happened, if you have an opportunity to submit an online application, that is a better way to go, because while immigration officers are working from home, they can work on online applications, but any paper applications are on hold.
Okay, thank you. So question from Claire is asking, is the $27 an hour for a full-time employment? If a person works in a part-time position but earns more than $27 an hour, does he or she meet point 2?
So that's similar to the question before. So the guidelines at the moment is just that you have to meet the $27 per hour salary wage. But as I say, it's very important to check what your visa conditions are on your work visa, because often these may be full-time hours that you are required.
Yeah. Okay.
And this is a very good point, because if you submit, and thank you for bringing this up, because it's just made me think of this. If you are submitting a residence application based on the fact that you have an eligible work visa, then it is very important that whatever you submit with your residence application does not show or does not make immigration think that you may be working in breach of your current work visa. So this is a consistency issue as well. So for example, if your current work visa has conditions that require you to work for a certain employer, which they often do, or in a full-time position, or under occupation, then it is very important that your residence application under this policy shows that you are actually meeting all those conditions. Because if you submit a residence application which shows that you are actually working in breach of your work visa conditions, that will cause problems.
Okay, cool. Thank you. So question from Meg is asking, my residence visa application was delivered at 6:55 a.m. on 29th of September. As it will be applied on 1st December.
Sorry, so residence application?
So she's asking that, her residency visa application was delivered at 6:55 a.m.
Right. Now, when you submit a residence application, you should get a confirmation from Immigration New Zealand, and that confirmation should have a date of lodgement. If you don't, then you should contact Immigration New Zealand to find out the date of lodgement. Now, if the date of lodgement is the 29th of September, hold on, just give me 1 second. Then you should be able to apply from the 1st of December. But again, it's just making sure that date of lodgement with Immigration New Zealand does match up, and you should be able to get that information through Immigration New Zealand.
Right, okay. Maggie, I don't know whether we answer your questions. Yeah. Nerden. So this one is a further clarification from Nerden, saying that we provided medical certificates and police certificates with our residency applications last year. Do we need to provide new medicals and police certificates again on 1st of December?
Right. So at the moment, the full policy hasn't been issued. And so we will not know for sure until the full policy has been issued. But the general feeling, or what immigration have put out, is that in some cases and in most cases, you probably will not need to resubmit a new one.
Okay.
Yeah,
right.
But I can't confirm that fully until the actual policy is put out, but probably not.
Right, okay. So question from Eric is like, would countdown checkout officer work for this scarce list? Countdown checkout officer.
Or countdown checkout of the scarce. I'm not quite sure. Eric, if you could just clarify that question, please.
Because I think on your list, you were saying like there's a scarce list.
Oh, yeah. There's look, the occupations on those lists, there's hundreds and hundreds. So that is something that you'd need to, I couldn't check it up for you right now. You need to check that after, or contact us after to check that. Yeah.
Yeah. Okay, so we got another question from Brenda. I meet the first condition, but my post-study work visa expires in November next year. Affected by the pandemic, I don't have a good job to support my work visa now. Before the residency visa will be approved, my post-study work visa will expired. What can I do? Thank you.
So if your post-study work visa is still valid, or was valid on the 29th of September 2021. Yeah. And if they meet the other criteria, then they would still probably be eligible to apply. Yeah.
So what will be, and then like, for people they are not so sure, do you want them to contact your office now? Or?
So what we are offering at the moment is an assessment. So contact our office, and we do what's called an assessment based off some information that we will ask. But at least on that assessment, we will see whether you meet the criteria or you are eligible, and also under which phase you can apply. So whether you'd be eligible from the 1st of December or from the later phase 2. So if you contact our office, PCW Law, then that is definitely a good way to get the process going and to check your eligibility. And if you have any concerns or questions regarding, like we've had tonight, some good questions about your personal circumstances or your personal visa, then that is a good time to discuss them as well. I will say if you have any concerns or you're not sure, then do seek advice about it.
So for your assessment, is it a free assessment or does it come with a fee? Yeah.
It is a free assessment.
Oh, that's nice. Yeah.
At the moment. So it is just some general information that we will ask for, and then we will provide. So we have what we call like a assessment checklist, which will be sent to you. We try and keep it as simple as possible for everybody. That will be sent out to you. And then from there, we can do an assessment on whether we think you will be eligible based on the criteria that is put out at the moment. And as I say, which phase you would be looking at applying under.
Okay. Got another question here from Lexi. My open work permit expires on this year, 14th of December. Will the immigration reviewed or not? Do I need to renew the skilled work visa now?
Yeah.
Okay.
Yeah. So if you have a temporary visa that is due to expire, you must apply for a new one. It is always your responsibility to make sure that you are in New Zealand on a valid visa. So even if you make an application for residence, that's not going to be granted on the same day. It could, as immigration is saying, it could take up to 12 months. And during that time, you must make sure that you still remain on a valid work visa. So immigration policy in general does not allow an immigration officer to process a residence application for anybody who is in New Zealand unlawfully. So that is why it is very important that if you are in New Zealand and you have a residence application pending, you make sure you stay on a valid visa.
Yeah. Okay. So Darren's got a quick question here. So will it give us interim visa after we submit the application?
No, interim visas are only granted for when you make a temporary visa application. They're not granted for residence applications.
Oh, right. Yeah. Okay. All right. Thank you, Mom. And then I've got a couple of questions here. So why, your opinion, basically, like why they suddenly make a U-turn? Because we know that, since Labour government come into power in 2017, they have been very, very anti-migrant. They limit the numbers. They, make it the harder to apply and everything, so why are they suddenly making this like a U-turn? Yeah.
It's definitely the impact of COVID, without a doubt. And it is definitely because since COVID and our borders have been closed, and look, I hear this in so many different industries, construction, hospitality, across the board, that there are not enough workers in New Zealand. So they've had to find a way to simplify it. We've had a lot of people in New Zealand working, and we need to keep them. So that's why that is what this is trying to address. Because as I say, we will lose people. If people do not have any certainty about their future or about how they may have a pathway to residence, then we will lose them. And at the moment, it's just we can't afford to do that.
Yeah. So just now you also mentioned the time frame is kind of looking at 12 months. Is that so? Basically, if someone submit an application on the 1st of December, they probably won't be able to get their residency for another year. Is it?
That's correct. So that's the estimate given by immigration at the moment, that it will be 12 months. I must say that's faster than any skilled migrant processing at the moment. But they have said, immigration said in some cases, it may be faster, but I always say, look, if immigration are estimating 12 months, then plan for 12 months. If you get it earlier, then that's bonus and that's good, but always plan on what immigration is saying.
Okay, because what happened is because talking about on the property market, like once this policy pop up, like suddenly the property market just goes crazy. People are just out there started worry about it, will be more people be qualified, because those people on the work permit, they at the moment they are considered as overseas buyers. So there are a lot of property they cannot buy. They can only buy certain type of property, right? Yeah. So I think that once that as soon as this policy actually been released, I think that was it a Thursday or something? Yeah. And then it went crazy, it's just like everyone's just screaming that, and we can see clearly seeing that, house price that, probably already shoot up that, more than 15%, so, but the reality is that obviously for this group of people, it's still got a number of months for them to be ready, because, to get their residency. And I believe that, a lot of them, they are probably not in a position, say like probably don't have enough deposit, or even like some of them, they probably don't even making enough income to actually servicing. But that's what happened on the property market anyway. I kind of just kind of share with you what's happening.
That's interesting, and I do wonder if that's because the property market starts getting very active again, because all of a sudden people might see that, there is a little bit more certainty now around the fact that we may be able to settle in New Zealand, whereas before we've just come out, we've had a very long period since at least May last year, I would say, where there's just been a lot of unknowns. And now we're starting to see some movement by the government addressing these and just being able to provide people with a bit more certainty.
Yeah. And also, and another thing that I'd like to share is probably my view of the New Zealand's economy is actually not really doing well, due to the the lockdowns, the Delta outbreak and things like that. Yeah. So just if you are out there, decided to actually investing in property, you have to be, I keep saying this, is be a bit cautious now. I mean, just talking about right now. Yeah. But again, obviously you are not buying the market. You are only buying single one property. So make sure that it's something that, allows you to actually add value. So it's keeping you safe, from the, because the value can fluctuate, and that means that some people might be in trouble. So if you want to know more about it, we do actually running a workshop that coming Saturday, which is how to buy or invest in Auckland property. So basically we're teaching you that how you can actually add value to the property to actually making yourself safe. Yeah. All right. Yeah. So I don't think we got any more questions. So a number of thank you notes, from the people, with us tonight. Yeah, we got Darren, Harina, Oscar, is that? Yeah, Sukana. Yeah. Okay. Yeah. Right. So I don't know, Anna, do you have anything else that you want to add, or? Yeah.
No, I think I've probably, as people can probably tell, I'm quite passionate about immigration law. And I have some quite firm views about the way that a lawyer's role in helping people with their applications. So I think I've probably got that across and talked everybody's ear off.
Yeah,
I can talk for a long time about it.
Yeah, and do feel free to actually reach out to them, because they offer this free assessment. And again, do seek the professional advice rather than trying to DIY, because I think their fee is really reasonable, in terms of the being a professional immigration lawyer. So you want to get this right. You don't want to actually make any mistake on this once in your lifetime opportunity. Okay, so good luck with you, and thank you. To join us tonight, and enjoy your rest of the evening. Yeah. Good night.
Thank you. Thank you, everyone. Have a good evening.